Tyler Robinson, the 22-year-old man accused of fatally shooting conservative political activist Charlie Kirk, appeared in the Utah court Thursday for the first time in person since his arrest. Robinson wore a light blue shirt, a striped tie, and khaki pants, and was seen on camera speaking to his attorneys. Robinson has been charged with aggravated murder and felony use of a firearm, as well as obstruction of justice, witness tampering, and commission of a violent offense in the presence of a child. He has not yet entered a plea to the charges. A 3-day preliminary hearing has been set to begin on May 18, 2026. He smiled at family members sitting in the front row of the courtroom, where his mother teared up and wiped her eyes with a tissue. Robinson's father and brother sat next to her. The defendant had previously appeared in court via video or audio feed from jail. Robinson surrendered to police on September 11th, a day after the shooting. The hearing focused on issues of transparency and public accessibility to the case. The issues stem from an October 24th hearing, which was closed to the public, about courtroom security, media coverage, and Robinson's ability to wear civilian clothing. Media organizations have requested a transcript of that hearing, but attorneys for Robinson and for the state of Utah have proposed certain redactions to the transcript. On December 11th, the judge closed the first part of the hearing to the public in order to freely discuss what should or should not be sealed. The closure lasted more than 2 hours.
So I just want to clarify, the issue really, if we boil it down, is if these 23 media entities have met their burden to be a limited purpose party in this case. And I think another part of that is what that means. And really that is what we are primarily concerned with. What does that mean? What does that enable them to do? What jurisdiction is this court exercising over them as a result of them being a limited purpose party? Because I do believe that is another aspect of asking to intervene in a case. I do think that Rule 24 does not apply here. I think that's what we learned from the Supreme Court. They don't want individuals using Rule 24 of the Rules of Civil Procedure because it's too expansive. It's about broad entry into a case for many purposes. In the instances where our courts have allowed intervention into civil cases, and I want to be very clear here, the case law is in the civil arena. There are very few instances where we're dealing with this in a criminal case on appeal. So we're a little bit in the dark, and we're asking this court to kind of wade through and make a decision that potentially hasn't been made before. But I would ask the court to be very clear, no matter what it does, on what the media can and can't do in this case. And it sounds to me like the media has somewhat conceded that their role in this case is under Rule 4-202.04, and their role is to have a voice regarding closure, which has already happened today and will surely happen again. We have no objection to that. And to be clear, we're not objecting to the court's order about notice. We will provide notice. We will follow the court's order. We have no problem with it. But we do want this court to make the procedure very crystal clear. We want time frames. We want orders saying this is when you need to respond, so that we don't end up with filings like we did this week, very shortly before the hearing, that we have to rush to respond to. We're all attorneys. We all know that these things happen from time to time, and we're not unreasonable folks. If they reach out to us, we will grant reasonable requests for extension, just so everyone is aware. But there was no communication. So I want it very, very clear what they can and can't do. It's less about semantics. This isn't about semantics. It's about substance. What are they allowed to do? If this court wants to call them a limited purpose party, that has to be, well, it's so you can exercise your rights under 4-202.04. And in doing so, this is what you need to do. That's what we're asking the court to do. And I also have some practical concerns that maybe need to be addressed with the court's clerk. for example, are we adding all 23 media entities to the court docket? Will they have access to all of the filings? I have had instances in the past where, unfortunately, parties have been added to a case and still receive documents that are intended to be private or non-public. I'm very concerned about that. So I think it would be appropriate, if they are going to be added to the docket, that it be reasonable, perhaps just the two entities that are requesting, the two conglomerate entities that are requesting, and that there be an order from the court saying if they receive something that they shouldn't have, they notify us in the court immediately and they delete it, they don't review it. At a minimum, I think that's necessary. But I also think it would be reasonable for this court to not to put them on the docket for that very same reason. So we don't think that they should have permanent status in this case. We don't dispute that they are going to be here. They're already here, as we well know. But we do think how that happens is important, and that this court should exercise its authority to make very clear what everyone's roles are here. And as I believe they put in their briefing, that they are neutral observers. Neutral observers. We don't want the chaos that is out in the media in this courtroom. So whatever this court can do to prevent that is what we're asking. Does the court have any questions for me?
No, thank you.
Thank you.
Counsel, I'll turn to you. Again, this is a goal. This is not a date that if we can't meet, there's any prejudice that will be attached to a party. In regards to May 18th, how does that tentatively look for counsel?
May or June?
May 18th is the first date, I believe.
Oh.
So 18th, 19th, and 21st, just to give you the full range.
The state can make those days work, Your Honor.
Okay, perfect. Your Honor, we have availability the May 18th with the understanding and the appreciation that if it's not feasible for us to get done when we need to get done prior to that, we would ask to push it back. But we don't have conflicts at this time.
All right, thank you. So May 18th, May 19th, and May 21st. And it will be in person, and do we anticipate, if that date moves forward, Mr. Robinson being in attendance?
Absolutely.
All right, thank you. I just want to put that on the record as well. All right, I don't want to be presumptive, but is there anything else? All right. Counsel, thank you again for your hard work today, and I wish you all, Mr. Robinson, a good afternoon.